Welcome to the college's webinar on private practice. We are very pleased to be talking with you today, and we're very hopeful that you're going to find this a useful resource. My name is Christina Van Sickle. I am the Director of Professional Practice here at the college, and this is my colleague.
I'm Jennifer Burt-Yanoff. I'm the Professional Practice Associate here at the college.
Our role in the Professional Practice Department is that we contribute to the development of resources, just like this webinar, to assist members in their practice, and that we oversee the continuing competence program. We also respond to inquiries from members on a regular basis who are having issues with practice dilemmas or other practical issues that they might need some help or some consultation with. We also speak with stakeholders and clients as well. We also have the privilege of being able to go around the province and present on a variety of different topics. Every presentation at the college begins with these words. These four concepts help describe what the public can expect when they're working with a college member. Through membership with the college, members demonstrate that they are professional because they subscribe to a code of ethics and standards of practice, that they practice ethically, that they're qualified through their credentials and also through ongoing participation in the continuing competence program, and that they're accountable. And members are accountable to their clients, to themselves, and of course to the college. Our work at the college is grounded in these concepts, and you're going to hear them reflected throughout the presentation today. So these are the issues that we want to be touching on today. There are many factors to consider when considering going into private practice, and the college responds to inquiries most days from members who are contemplating these different factors. And so we've tried to gather what are the most frequently asked questions and issues that we consult members about when they're considering going into private practice. This isn't an exhaustive list of considerations. However, we're very hopeful that the information that we present to you today is going to help get you started and point you in the right direction. We do have Aaliyah, who's the Professional Practice Administrator, who's going to be our moderator today. She's off camera. As the standards of practice are foundational to ethical and professional practice, that's where we're going to start our conversation today.
As you know, the Standards of Practice Handbook contains 8 principles, and they set out the minimum standards of practice for professional ethical practice that you provide to your clients. For each of the principles, there are interpretations which outline and provide guidance to members when providing services to their clients. The standards of practice are meant to be applied to your practice with your clients in conjunction with any applicable privacy or other legislation. For the purpose of the webinar today, we're going to highlight some of the principles which apply and are to be taken into consideration when beginning a private practice.
So working through the principles, we obviously start at Principle 1. And Principle 1 addresses that members must consider when engaging in therapeutic relationships with clients. A purpose for the work between the college member and the clients must be established, and members must respect and facilitate client self-determination. And members also must be mindful of their own values, attitudes, and needs, and how these could impact upon the clinical relationship. Now, it might sound obvious that members need to be aware of their own values, attitudes, and needs when working with clients, but private practice can present a more isolated working environment, in which members are going to be dealing with client stress and trauma on their own. And at times, these can be very difficult situations to navigate independently, and it can be very helpful to have a self-reflective practice during this time. Moving along, we look at Principle 2. And in Principle 2, we're looking at competence. And competence is a key factor when we're considering private practice. It actually might be the factor to consider when we're looking at private practice. And when Jennifer and I are dealing with consultations every week, members are calling us up and they're asking us, how do I know if I've got the knowledge, skills, and judgment to go into private practice? And they're exploring what their own competence means. And these are really good conversations to have and really good thoughts to be processing. And it has been said in other college resources, and it's going to be said here again, that serving clients in private practice is not an entry to practice competency. The skills to safely, ethically, and professionally provide client services in a private practice setting are honed after practicing in the field and obtaining ongoing supervision and training. In fact, in Principle 2, Interpretation 2.11, it states that college members are responsible for being aware of the extent and the parameters of their competence and the professional scope of practice, and limit their practice accordingly. Now, this interpretation further explains that members who wish to grow their skill set may seek additional supervision, consultation, and education. And this includes setting learning goals and activities in their CCP each year to build the skills needed for private practice. The practice guidelines for performing the controlled active psychotherapy and the practice note titled, "But How Do I Know If I'm Competent?" are resources the college has developed to help members reflect upon their own competence. Now, you're going to notice that throughout the presentation today, we're going to be highlighting a bunch of different resources. And if you go onto the college website and you look along the headings at the top, you'll see the Professional Practice tab. Under Professional Practice tab, if you go into General Information, on the right-hand side of the page, you're going to see a list of pink resources there under a title called Practice Resources. And that's a way that you're going to be able to navigate to most of the resources that we're discussing today. Also, at the end of the webinar today, we do have a resource that has the links to all of the resources that we're discussing today, so you're going to be able to navigate them easily. Moving on, another common theme that we discuss with members when they call us for consultations is that they need to be very aware of the legislation that impacts their practice. And again, this is reflected in the standards of practice. 2.13 states that college members maintain current knowledge of policies, legislation, programs, and issues related to the community, its institutions, and services in their areas of practice. Now, when we talk about this with members, sometimes they're unaware of this, and legislation sometimes isn't an issue that members have given a lot of thought about when they're thinking about private practice. But knowledge about the legislation that applies to private practice is essential. For example, members are going to need to be aware of legislation that applies to consent and privacy, and we're going to touch on these issues a little bit more later.
Lastly, members often contact the professional practice department to consult on issues related to dual relationship and conflict of interest. It's important to remember that members do not provide a professional service when they find themselves in a conflict of interest. You will find a definition of conflict of interest in footnote 6 of Principle 2. But essentially, a member must ask themselves when they're working with a client if there's another interest or factor, such as a personal or financial one, that could impact upon the professional relationship with the client. An example of this can be found in, for example, consider that you are treating a client. They request that their sister accesses services from you as well. Could a reasonable person perceive that you have influenced your client in referring their sister to you? Could you stand to gain financially? It's not that you cannot see the sister, but it's wise to turn your mind to some of these considerations. A dual relationship occurs when a member has another relationship with the client in addition to their professional relationship. This does not necessarily constitute a conflict of interest. However, where there's a dual relationship exists, there's a strong potential for a conflict of interest. It's an issue about which members must be mindful of and seek consultation when they find themselves in these situations. Another example that we commonly hear about and use in our presentations to members, consider, for example, that you live in a small community. You could encounter a past or current client in a variety of settings. Imagine you take your son or daughter to a hockey practice and you realize that the coach is a past or an existing client. This creates a dual relationship, but may not necessarily constitute a conflict of interest. Each case, and this is an example where we would ask that you critically analyze the situation and consider all the factors before deciding how to proceed.
Now, looking at Principle 3, as the name suggests, Principle 3 focuses on a member's responsibility to clients. And when we're conducting consultations with members, the interpretations from Principle 3 that we often reflect upon is 3.1 and 3.6. And they read that college members must provide clients with accurate and complete information regarding the extent, nature, and limitations of any services available to them. And college members inform clients of the foreseeable risks, as well as rights, opportunities, and obligations associated with the provision of professional services. So clients need to be provided with this information at the outset so that they understand what services are being provided to them. And this allows them to make an informed decision if they want to receive the member's services. This issue is more fully described in the practice note, Setting the Table, Issues to Consider when Initiating Client Conversations. This practice note is a good resource because it has a checklist at the end of it for items and issues to consider about what to include in these important initial client conversations when the therapeutic relationship is being established.
Principle 4 talks about the social work and social service work record. We know that documentation is an essential component of our professional practice and provides a means for understanding the client and the planning of the interventions. The record documents your services in a recognizable form to ensure the quality of the services and the interventions provided, to establish accountability for your services and evidence of the services rendered to your clients. College members ensure that records are current, accurate, contain relevant information about clients, and are managed in a way that protects client privacy and is done so in accordance with any applicable privacy or other legislation. Members in private practice need to keep client records for 7 years. In some cases, you may choose to keep records longer, or there may be required as in the standards of practice. And you are responsible for ensuring that you keep them in a safe and secure place. Members must be knowledgeable about the maintenance of the record, who is able to access it, and how to make corrections to the client record. Some members document in a paper chart, while others choose to use online documentation formats. Whichever modality that you choose, remember that you must ensure that the practice aligns with the Code of Ethics and Standards of Practice and with any applicable legislation in Ontario. Members also need to be mindful about how they will document if they are working, for example, with couples or groups. Consider this example. If you are working with a couple who is seeking counseling services from you to work on repairing their relationship, however, some weeks into the sessions, one of the members of the clients decides to cease services and is requesting a copy of the record. Principle Interpretation 4.4.2 discusses that when members receive a request from a client to disclose information that pertains to more than one client, that the college member only provides access to the record for those who have provided consent. This requirement can influence the documentation strategies that you use when providing services to client groups. It also signals that members should have clear and transparent conversations with their couples or groups at the outset of services regarding how information is going to be recorded, how it will be accessed, and how the information will be stored.
Looking at confidentiality, it is the cornerstone of all professional practice. College members respect the privacy of clients by holding their information in strict confidence. College members, we know, must obtain consent to the collection, use, or disclosure of client information unless otherwise permitted or required by law. So it's essential for members to inform clients about the limits of confidentiality early in the professional relationship, and this is further explained in Interpretation 5.4. In clinical practice, college members explain to clients the need for sharing pertinent information with supervisors and administrative coworkers, for example. And also when members are required to disclose personal information, such as making a report to the Children's Aid Society when there are reasonable grounds to suggest that a child is in need of protection. Clients need to be provided with this information at the outset of services, so that they have this information that they can therefore self-disclose and choose what information they're going to self-disclose during the session. As mentioned, members must be aware of privacy legislation. And we've had this conversation with a lot of different members who they feel that the PHIPAA toolkit is a very useful resource. And it's another one of the resources that we have on our website. Now, for those of you who aren't aware, PHIPAA is the Personal Health Information Protection Act. And our toolkit explains, among other things, what it means to be a health information custodian, which is also known as a HIC, and also the associated rights, responsibilities, and obligations of being a HIC. The PHIPAA toolkit, as I mentioned, can be found on the college website. And all of this is to say and to really underscore that to remember when you're in private practice, you're the person who's responsible for safekeeping your clients' records and also ensuring that their information is kept confidential.
Setting your fees is also another very common practice scenario that we get called upon. The college does not determine what fees members should charge their clients. This is a business decision that can be made in consultation with an accountant, a lawyer, or other private practitioners in the field. Principle 6, however, does indicate that college members do not charge or accept any fee which is not fully disclosed. Members must explain it in advance or at the commencement of a service the basis for all charges, and give a reasonable estimate of projected fees, pointing out any uncertainties involved so that clients can make informed decisions. An example of such is professional practice often gets calls from members whose clients dispute bills at the conclusion of services because they were not fully informed of the basis of all charges at the commencement of services. It is advisable to have these such agreements in writing. Another interpretation within Principle 6 that is regularly discussed in practice consultations is Interpretation 6.16. College members do not accept, give commissions, fees, rebates, or anything of value for receiving or making a referral. This interpretation is in place to help mitigate the potential for a conflict of interest. If members were able to give or receive fees for client referrals, it could set up a financial conflict of interest that could affect a member's obligation and challenge whether the client's interests are remaining paramount.
We're going to look at advertising, because certainly if you're in private practice, you want to consider advertising. And college members may advertise their services through public statements, announcements, advertising media, and promotional activities, provided that the statements made are not false or misleading, any factual information is verifiable, and that they do not compare services with other college members. So additionally, college members don't include any endorsements or testimonials in their advertisements. Again, accepting endorsements or testimonials can set up a conflict of interest situation, similar to what Jennifer was just discussing. Due to the inherent power imbalance in a therapeutic relationship, clients might feel that they have to give a glowing endorsement in order to receive continued quality of care.
Principle 8 is sexual misconduct, and although it may be obvious about and be mindful about this in principle, it is still worth mentioning for members. Boundary violations can and do occur. Due to the isolated nature of private practice, the risk for boundary violations may be increased, and members must be vigilant about maintaining appropriate boundaries. Members are reminded that sexual abuse of a client can include touching of a sexual nature, behavior or remarks of a sexual nature by the member towards the client, other than those are clinically appropriate for the services provided. Also, a sexual relationship between a client and a member to whom the member has provided counseling or psychotherapy is prohibited at any time during or after the termination of the services. This issue is further explored in the practice note entitled The Slippery Slope to Sexual Misconduct. Be informed, be aware, and can be found on the website as previously described by Christina.
So we're going to switch gears here for a little bit, and we want to explore some of the practical considerations that we discuss with members during our practice consultations. And there are many practical considerations, and we're hoping that we're touching upon the ones that are the most frequently asked questions, the most common issues that we get asked about when members are considering setting up their own private practice.
So the first one to consider is purchasing liability insurance. Obtaining professional liability insurance is highly recommended by Christina and I, especially when engaging in private practice. Often members have legal queries when they call the professional practice department, and for a number of reasons, Christina and I are not able to offer a legal opinion. Professional liability insurance provides a legal consultation and representation in the case of a complaint or discipline case before the college. Many members purchase their liability insurance through the Ontario Association of Social Work or the Ontario Social Service Work Association. More information on these associations can be found at the end of our webinar.
So looking at fees, we've previously mentioned that the college doesn't determine the fee rates and schedules that members should charge their clients. This is a business decision and requires consideration of many factors, such as cost of overhead, cost of your time, and of course the financial needs of your clients. Similar to the previous slide, the OCSWSSW can be a resource for obtaining information on the operational aspects of setting up a private practice. The OCSWSSW has resources and supports that specifically address the needs of those in private practice, including the setting of fees. From the college standpoint, it is critical that the fee schedule has been clearly explained to a client before they agree to obtain your services. As Jennifer mentioned earlier, we've heard from members who haven't had these conversations clearly at the outset of services, and then when service terminates, they're not getting paid by their clients, and they don't have a lot of recourse or any information to fall back on to state that this is the information that we agreed upon at the outset. College members must seek an agreement, preferably in writing, that outlines the basis of all charges and billing procedures at the time of contracting service with the client.
Another practical consideration is drafting your forms. Professional practice hears from members weekly about whether the college offers or has sample templates that members can use in private practice. The college does not provide templated forms for members to use in private practice. This is largely due to the fact that members work in a variety of different client settings with different client groups, different contexts, and different locations throughout the province. It would be impossible to create a template that would meet the needs for everyone. Members should rather consider the specific needs of the client groups that they are serving, draft forms accordingly, and with the assistance of a legal consultation. There are many issues to consider when creating the forms that members should use in their practice. Some of them have been previously mentioned, but I will include them here. The nature of services provided must be clearly explained. Members ensure that services are explained in such a way that they can be reasonably provided and consented to the services. The limits of confidentiality have been clearly articulated. Are clients aware that when members have mandatory reporting obligations, whose information they will share, and in what instances members can and will receive information from clients, and with whose consent or without consent? Also, are clients aware of what information will be included in the record, who will have access to it, and when they will have access?
Another consideration, members need to explore if they're going to use social media or digital or electronic communication in their practice. And when we're saying electronic or digital communication, what we're really talking about is social media platforms, texting, and emails. So members need to determine if they're going to communicate with clients via these means. And if they are going to communicate with clients this way, a robust policy needs to be created and shared with clients to ensure the maintenance of professional boundaries. We've heard from members who have received emails from clients at 2 o'clock in the morning on a Saturday morning endorsing a crisis, and then the client was very upset because the member didn't get back to them quickly. And of course, it's understandable the member didn't get back to them quickly. But the issue was that the member didn't set down boundaries or guidelines about when they would get back to the client. We've also heard from clients who were communicating with their member or their social worker or social service worker, and they were communicating via text, via email, and due to the informal nature of this type of communication, these clients didn't think that this information was going to go into their record. And months down the road, they request a copy of their record and find out that their texts and emails are contained within. And they were quite concerned and upset because they didn't think that this information was going to be contained in the record. So, some items that you would want to address in a social media or electronic communication policy could include if you have clearly articulated to clients how often you're going to check messages and whether or not you're going to respond to those messages. You're also going to figure out how you're going to respond to a friend request on a social media platform. And if you have explained what information is going to be documented in the client record, including information gained from texts, email, and on the internet. And there are practice notes on the college website that address communication and technology. These resources discuss what members should consider when creating a social media policy. And these articles are very useful and they can help guide members' thinking with respect to this issue. And again, if you're going to be looking at our resources that we've talked about on the practice notes page, you go to the bottom of the page, there's a heading that says technology, and all 3 of those practice notes are contained there, and they'll be helpful for you to find.
So another consideration is putting a contingency plan in place for storage and maintenance of your documentation. In the standards of practice, principle for the social work and social service work record, in interpretation 4.23, it states that college members ensure that each client record is stored and preserved in a secure location for at least 7 years from the date of the last entry. Or if the client was less than 18 years of age, to the day on which the client would have turned 18 plus 7 years. However, sometimes unforeseen incidents occur, and for a variety of reasons, you may no longer be able to be the custodian of your client's documentation. The professional practice department has spoken to members in private practice who have retired or no longer are able to be the custodian of the client files for a number of reasons. And to clients whose social worker or social service worker has passed away and they are no longer able to locate their files. Interpretation 4.24 states that self-employed members who cease practice may maintain their records in accordance with interpretation 4.23, or they may make arrangements to transfer the records to another college member or to another rated professional. If a member chooses to transfer the records to another rated professional, the person must first agree to comply with their interpretations as set out in Principle 4. This must make reasonable efforts to give notice to their clients of the future location of their records. College members also must comply with the requirements regarding the transfer of records as set out in any applicable privacy and other legislation. Unfortunately, professional practice has heard from several clients whose social worker or social service worker has passed away, and they are no longer able to locate or access the record. In this instance, there was no contingency plan for the storage of the records. This is an essential component of private practice and is something that we want you to turn your mind to.
So members are permitted to incorporate for the purposes of practicing social work or social service work, provided that they obtain certificates of authorization from the college. There's information on the college website that outlines the conditions for the requirements that must be met in order to obtain a certificate of authorization. Now, determining whether or not to incorporate your practice is a personal decision. Jennifer and I can't help you with that decision, and other college staff members can't help you with that decision. This decision to incorporate is going to be based on your own practice context and personal situation. Some members choose to incorporate and others don't. When deciding if you're going to incorporate your practice, you may wish to seek advice from qualified professionals such as a lawyer or an accountant or other professionals who've incorporated their practice. These individuals are going to be able to help you understand better what are the risks and benefits of incorporation. Generally, some benefits may include tax deferral and favorable small business corporate tax rates.
Another consideration is choosing your practice space. Some members have considered practicing out of their home. While this could certainly offer flexibility as well as some financial benefits, members would be obliged to consider the risks involved in such an arrangement. For example, shall members consider their own safety, as well as the current and potential clients when they are working in a home setting? Could practicing out of one home lead to potential boundary violations, such as offering appointments at irregular hours or dealing with personal issues while at work? Members would need to consider who else could be coming in and out of your home. What could clients learn about you as a result? Could this be a form of unintended yet inappropriate self-disclosure? How would clients' confidentiality be protected while practicing out of your home? Practicing out of your home office has the potential to make it difficult to set clear boundaries between a member's professional and personal life. And the member would need to carefully consider how to proactively address these issues. This issue is further explored in the practice note, Private Practice, the Cost of Doing Business.
Competence in private practice requires not only formal education and extensive experience, but ongoing clinical supervision. The need for supervision does not end after a certain point in practice, however, evolves and continues throughout a member's career. Good supervision increases job satisfaction and protects practitioners from burnout. More importantly, it promotes high quality of care for the clients and is required by the college's standards of practice. Now, a distinction must be made between clinical supervision, which is associated with the assessment, intervention, and evaluation of the client's interventions, as well as critical self-reflection, and administrative supervision, which is primarily concerned with the instrumental aspects of practice. Administrative supervision typically focuses on record keeping, policies, and business practices. And while it's very important and necessary, it's not sufficient for members who are wishing to engage in private practice. As members gain experience, less frequent and more informal models of supervision may be appropriate. Members should seek supervision and consultation with experienced colleagues throughout their careers, particularly in areas of practice where they are less experienced or when they're aware that they have a strong reaction to a client, either positive or negative, or when the client could benefit from members gaining an additional perspective, outside expertise, or a new skill or approach.
We often get asked about supervision and certain strategies that we can consider when looking for supervision. A traditional model of supervision is where someone is provided with supervision from someone of the same profession. In the private practice context, often this means contracting with a supervisor and paying out of pocket for ongoing supervision that is scheduled based on the member's needs. Members may be supervised by someone outside of the profession who has relevant expertise and experience in their area of practice or setting. In this case, they should consider whether the supervisor has an understanding of the profession's values, ethics, and standards of practice, and determine whether additional input from other sources may be required to maintain the profession-specific supervision that they need. Whatever their profession, supervisors should be members in good standing with their respective regulatory college. When using a peer consultation model, members often find that a structured format in which a regular scheduled time to meet with a colleague or peer is most effective. Members choosing a peer model must be personally accountable to bring forth challenging cases. Sometimes in private practice, it can be challenging to find a peer with whom to consult. So some members have identified that they've benefited from joining a peer supervision or consultation group. This group may include members of one's own profession or other regulated professions who meet on a regular basis to bring forth challenging cases on which they would like to consult. Regardless of the extent of the experience or the model of supervision or the consultation used, members should ensure that they fully inform their clients in their relationships of the limits of confidentiality of the information, and explain to clients the need for sharing pertinent information with supervisors. Members should also be aware of Principle 5. Confidentiality distinguishes between consultation and supervision in the area of sharing client information, in that in consultation, clients are not identified. An example of this is when members consult with Christina and I for consultation, client identifying information is withheld.
So we want to take this opportunity just to make a link between the Continuing Competence Program and private practice. So we know that the primary purpose of the CCP is to promote quality assurance with respect to practice and to encourage members to enhance their practice in an ongoing way. Ensuring that all members continually participate in the CCP is one of the ways in which the college fulfills its mandate of public protection. When in private practice, your CCP should be heavily weighted to include learning activities related to your enhancing your competence regarding the clinical services that you provide. And we just want to look at the CCP steps for a second as well, that we understand that the CCP requires review and reflection. Members must review the standards of practice and other relevant documents. When setting up a private practice, it would be a good idea to review the practice notes on private practice and also the practice guidelines for performing the controlled active psychotherapy, whether or not you intend to perform the controlled act. You'll also need to reflect and complete your self-assessment based on what knowledge you will need to gain in order to start your private practice. Consider with whom you might consult, be it other private practitioners, a lawyer, an accountant, the professional practice department. And many learning goals can also be created when you're looking at the practical issues, such as finding a physical space, setting up that physical space, creating your administrative processes, drafting forms and contracts, arranging supervision and obtaining liability insurance are just some of the items which could be included on your CCP.
As you move into the consideration for professional private practice, we want to remind members that professional judgment undermines all the decisions that we make. And this is why the college always stresses the need for regular and ongoing consultation, and to do so widely when faced with challenging ethical dilemmas and practice issues. In private practice, this can be more challenging because of the isolated nature of the work that you do. Additionally, the assessments, decision-making, and intervention of private practitioners can have significant impact on the lives of their clients. Honing your professional judgment and critical thinking skills are essential in private practice. Members must also ensure that they are able to track their decision-making processes and are able to provide evidence and rationale for their decisions. The college has developed an ethical decision-making tool called Ethics A, which is available on the college website for members to use when they're applying their professional judgment and when making challenging decisions. Members are led through a structured process of decision-making to aid them in navigating these ethical dilemmas and challenging workplace scenarios.
So again, just wanted to talk about the resources that we've discussed, and here are a list of the resources. And these can be very helpful to you and provide you with assistance when you are considering going into private practice and throughout your private practice. And we said that we are going to be providing a handout that has links to all of these resources as well. But just to review, that we are looking at the Code of Ethics and Standards of Practice, the PHIPA Toolkit, the practice notes, practice guidelines. And as Jennifer just mentioned, we have this brand new Ethics A tool. You can go and access it on the college website now. We're really excited about it. We hope it's a useful tool. Please use it. Give us some feedback on how you found it. And we just wanted to highlight as well on the slide right now that we previously mentioned that professional liability insurance is available on the websites of the Ontario Association of Social Workers and the Ontario Social Service Workers Association. So we're going to segue in a minute into the question period. We're going to have a survey where we're going to be asking for your feedback. So please do complete that and get back to us, because your feedback helps us create resources that are going to be impactful and meaningful. You're also going to have a CCP certificate as well, so that as participation in this webinar today, you can use that as part of your CCP. And there's the resource handout, as I mentioned. And also, please be aware that in about 4 to 6 weeks, we're going to be sending out an impact survey because we're really curious to find out about how this webinar impacted your thinking when you are considering private practice and preparing for private practice, to find out what the impact was. So we're going to segue now into our question period.
We'd be pleased to answer any questions that you may have. If we do run out of time, please note that we will get back to all of you individually. Additionally, if we happen to identify some common themes, we will explore whether we could write additional resources for members, for example, a possible question and answer type resource.
And look at an upcoming perspective.
So we got a lot of questions.
We have a lot of questions. Aaliyah's talking to us off camera right now.
So one of the questions that people are wanting to know is if a client is moving from one province to another or a different country, how, and they want to continue that therapy, how can they do so with online?
So somebody's asking about what we call out of jurisdiction practice. So social worker or social service worker who's working in Ontario with a client, and that client moves to a different province or out of the country, and how do we continue to work with that member?
So I guess there's a few considerations that I usually talk to members on the phone about. We want to consider the jurisdiction. In the place in which the client is residing, there may be considerations around title. The other consideration would be what might the clinical implications be for that client should they discuss thoughts of self-harm or harming behavior towards others. And the other one is, how do we provide a service ensuring that you're complying with the legislation in Ontario, for example, PHIPAA? Are you ensuring that confidentiality and privacy are being met when you provide these services to clients? We do have resources on the college website in the practice notes section, in the technology section, that further explore some of these considerations.
Another issue as well is that if you're considering working with a client who's in a different jurisdiction, that we recommend that you need to contact the regulator in that jurisdiction. So for example, let's just say you're working with a client here in Ontario, they move to Alberta, you're going to need to contact the Alberta College to find out what their requirements are for providing service to a member in their jurisdiction. I hope that answers the question. We've got 1 minute left. We might be able to do a real quick one.
So is there an outline on how to keep notes and records of sessions?
One of the resources where we always direct people to is in Principle 4, Footnote 2. People sometimes forget about the footnotes in the standards of practice. They're little nuggets of gold in there. So look at Principle 4 and Footnote 2. It outlines what are some of the considerations that need to be captured in a record. We, as the college, don't, as we talked about, have a form or a template that has to be filled out. We don't subscribe to a specific type of charting methodology, but we do outline Footnote 2, what are the items that need to be included in a document.
Footnote 3 would also explore identifying who your client is, what is the kind of services that you're providing, what is the assessment, the intervention, the treatment plan, the duration of services, have you moved through the termination, just to outline and capture the services that you provided to your clients and the interventions that you provided during that time period.
And I think that brings us to the end of our time today.
In closing, the webinar has highlighted some of the issues that members need to consider before entering private practice. And we've explored the resources which can further provide you with information. We hope that you have found this helpful. On the next slide, you will see our contact information should you wish to further discuss any of the issues that were highlighted today.
We've really enjoyed being able to speak with you today. We hope you found this helpful, and please contact us if you need to do so. Thanks so much and have a great afternoon.